So you have an awesome new idea that you want to protect, that you want to patent. What's the first step? The very first thing that you're going to want to do when you have an idea that you want to possibly patent is see if it already exists. What practitioners call this is prior art searching. So effectively, you're going to want to do some Google searching, and you're going to want to try to identify whether or not what you think is new is already out there or has already been done by someone else. Because you don't want to spend a whole lot of time, effort, and money on patenting something that already exists, because you're not going to be able to get it patented. It's going to be invalid based on prior art. So how do you go about doing this initial searching? Google is an awesome tool. If you go on Google and do some searching, you can search by keywords, put yourself in the place of someone that's trying to knock out your invention. So search for terms that might identify what you think you've invented. So look for terms that describe what you think is new or novel about what you've invented. If you've developed a new type of mechanical click pen, then you're going to want to search for mechanical click pen and then whatever's new about it. So if it has some special retraction mechanism, you're going to want to search for mechanical click pen retraction mechanism. So one tool also that's very useful is using images, so Google image search, because it allows you to sieve through a lot of information really quickly. So if you do a Google search on images.google.com, you'll be able to see a whole lot of different things that are already out there really quickly, and you can scan through them just by doing a Google image search. So really useful tool in identifying prior art that might be out there. Now, another tool is you can go to uspto.gov and you can actually search for published patent applications and issued patents. So uspto.gov, and then go to the patents tab, and you can find search for patents. Now, when you're in there, it's interesting because you can not only search by keywords in the specification and claims, but you can also search for possible owners of patents. So if you know a specific competitor that might have patents in a certain area, you can search for patents that are owned by that competitor. So you're only going to be able to find published patent applications or issued patents. However, it might be a good way of identifying what your competitors are doing and might lead to some patents. Now, another really useful tool is Google Patent Search. And the reason why I recommend using also Google Patent Search is because if you search on Google Patents, you can find a lot of related patents very easily. Now, if you do this search, you'll often find a lot of similar patents. And the good thing about all these tools, everything that I described, Google, uspto.gov, image search, or Google Patents, is that they're all free. So you can do all this searching at literally no cost to you except your time. So again, if you have an idea, the very, very first thing that you should do is you should try to see if you can find it. Just look around. Start spending time looking for what you think you've invented. Now, you might say, oh, but I think my idea is so good. I'm worried. What if I find it? Here's what's interesting. Even if you find something out there that's very similar to what you've done, there's a slight chance, in fact, probably a really good chance, that it's not identical. So there might be patentable aspects that you can still protect by claiming the nuances between what you've invented and what someone else has already put out to the world. Don't worry about finding your invention out there already, because the worst case is that you save yourself a lot of time and money, because if it's already out there, then you're going to save the costs of filing for a patent, hiring a patent attorney or patent agent. You're going to save yourself all those costs. And then even if you do find something that's similar, if you can identify differences, it might still be patentable. And you can present what you found to a patent professional and tell them what you think is different, and they'll be able to help you craft patent claims that might get around that prior art, but still bring you value and still bring you what might be a actual patentable invention that you can get an issued patent for. This initial searching is going to be really valuable, and you're going to have a competitive intelligence. You're going to learn a lot about the industry, a lot about the market, and it's going to make you a better competitor in the market, just knowing what's out there. So after you do this searching, if you don't find it, or if you find something that's similar but not quite exactly what you have, then you're going to want to find a patent professional to help you actually file a patent application to protect your invention. Now, this is under the class of utility patent applications. There's also design patents and plant patents, but I'm not going to talk about them in this video, but you should know that they exist. Design patents protect ornamental features of a thing, so the way something looks. Now, design patents don't provide as much protection as utility patents, but they're still quite valuable, and a lot of people decide to also file design patents in addition to utility patents. So Once you decide that you want to pursue utility patent application, as I said before, there's utility provisionals and utility non-provisionals. Provisional patent applications are a really good way and lower cost way of securing a filing date. So if you can describe in detail how to make and use your invention at the present moment, even if you haven't actually built your mechanical clicker or your whatever it is that you've invented, even if you haven't built it, as long as you can describe how to make and use it, then you have enough to file a patent application. So when you communicate that to the patent practitioner that's helping you, they should be able to craft a solid patent application that effectively reads like a cookbook that describes how to make and use your invention. Now, a provisional application never gets examined. It never issues into a patent. However, it secures a filing date. So once you file a provisional patent application, you will be patent pending. However, you have 1 year to file a non-provisional patent application that claims the benefit of your earlier filing date. So activity such as public sales or disclosures by other parties will not be prior art to your later filed non-provisional patent application if you can claim the benefit of that earlier filing date. So it's really important that you engage a patent practitioner because they'll be able to guide you through the patenting process of protecting the provisional and then filing a subsequent non-provisional. Now, some of you may decide, hey, I don't want to spend the money on a provisional. I'm going to straight file a non-provisional. So that's okay. However, I would encourage you to evaluate how developed your invention is, because if it's still in the early prototype stages, you might want to file a provisional first because it'll give you a year to really refine your product. Once you file the non-provisional patent application, that application will actually get examined and might turn into an actual patent. And so it's a really good idea to have a refined product before you file a non-provisional patent application. But again, provisional applications are cheaper. They have less formality requirements, so you can submit pictures, sketches, hand-drawn sketches, photographs. All these things that you ordinarily would not submit in non-provisional, you can submit in a provisional. This is not legal advice. I highly encourage you to retain a professional to guide you through the patenting process and to guide you through the patent office. They have tremendous amount of knowledge and skill and know-how and have been through the process before. I'm Amir Adibi with the Adibi IP Group. We are a law firm specializing in intellectual property, trying to help inventors protect their intellectual property with patents, trademarks, copyrights, and trade secrets. I hope this video helps you guys when you've come up with an idea that you might want to patent. These are some early steps that you can take to actually secure and file a patent application to protect your invention. The earlier you can do some Google searching or just general searching on uspto.gov or whatever searching tool you want to use, the better.